Hello everyone, I'm Jed Rubenfeld and this is Straight Down the Middle. Well, there's a lot of crazy stuff going on in the world today, especially in the Middle East, but I'm here to talk today about what's going on in Los Angeles. In particular, what's the deal, legally speaking, with the president's deployment of the National Guard and the Marines to Los Angeles? Is it legal or not? As many of you may know, a federal district judge, just last Thursday, Judge Charles Brier, issued an opinion saying, nope, the president's deployment of the National Guard was illegal. Judge Brier slapped an injunction on the administration and said, you've got to return the National Guard to the command of Governor Gavin Newsom of California, who had brought the suit. Now, that holding is stayed. The Court of Appeals has stayed that and scheduled an emergency hearing for a couple of days from now. So, question, is it right or wrong? Well, I'm going to try to explain all the legal issues to you, as I always do. I'm going to walk you through it, but you got to know two things up front, two things in advance, okay? First, there is ridiculously little case law on any of this. You'd be amazed. I mean, we're talking about very important statutes, but they're basically being interpreted for the first time. So, anybody who tells you they know what the law is, I wouldn't listen to them. I'll give you my opinion. I think there's a lot of weaknesses in Judge Brier's opinion. I'll tell you what they are. But anybody who tells you they know for sure what the law is on this subject, they're talking out of their ear. Okay, second thing I need to tell you about in advance. This is a matter of some background, some legal background, legal historical background that you got to know to understand what's going on here. First thing to know, 150 years ago, Congress passed a statute, a famous statute, basically barring the use of military force on U.S. soil for law enforcement purposes, as a general matter subject to some exceptions. Now, that's what a lot of people are getting up in arms about. That statute, that's called the Posse Comitatus statute. And people are saying, hey, President Trump's deployment of the National Guard and the Marines to Los Angeles, that violates the venerable principle of the Posse Comitatus Act. That's what Governor Newsom said. He said it's anti-democratic for the president to do that, send troops or the National Guard to California. Well, a lot of the folks making that claim, they don't know much about the history of the Posse Comitatus Act, and that's what I want to tell you a little bit about. Just a minute or two of history on this, it's important to know. The Posse Comitatus Act was passed in the 1870s in the aftermath of the Civil War. Here's what people forget. That act was rammed through Congress by Southern white supremacist Democrats who wanted to get the Union Army the heck out of the South. Why did they want to do that? Because the Union Army was there protecting the rights of the newly freed blacks to vote and to exercise other civil rights. And if the Southern Democrats could just get the Union Army out of there, nobody would be protecting those blacks anymore. For a period in the 1870s, there was mixed race governments getting elected to the state houses in the South. They were sending blacks to Congress, to the House, to the Senate. A lot of folks, white folks in the South at that time, felt we can just get the Union Army out of here. We can put an end to that. And guess what? They did get the Army out of there, in part with the help of the Posse Comitatus Act. And guess what? They won that battle. Black voting decreased by about 90% because the blacks were being terrorized. You had the Ku Klux Klan running around. You had other means of terrifying blacks not to exercise their right to vote. It would be 100 years before blacks started to be elected again to national office. So the Posse Comitatus Act, it's got a kind of an ignoble history. There's a lesson here. It is not always anti-democratic to use federal military force to enforce the laws. It was not anti-democratic when Dwight Eisenhower sent the 101st Airborne to Little Rock to defend black students trying to attend schools there, formerly all-white schools, from mob violence. It was not anti-democratic when John F. Kennedy sent troops to Ole Miss to enforce desegregation there. It was not anti-democratic when LBJ mobilized the National Guard, sent the National Guard to Alabama to protect civil rights marchers from mob violence. Now, I know what you're thinking. You're thinking, well, Professor, if Ike and JFK and LBJ could do all those things and that was legal, how could Judge Brier have possibly held that what Trump is doing, mobilizing the National Guard, sending the Marines to Los Angeles, how could Judge Brier have held that was illegal? Okay, that's the right question to ask, so let's go. What did Judge Brier do on the law? Let's get into the law. Judge Brier, he says there's a statute that authorizes the President of the United States to call up the National Guard. But that statute has conditions in it. The statute says the President can call up the National Guard if there's a rebellion against the authority of the United States or the danger of such a rebellion, or if the President can't execute and enforce the laws of the United States through the regular forces. That's what the statute says. And Judge Brier, he said none of those conditions was met here, so it was illegal. There was no rebellion, there was no danger of rebellion, so the deployment was illegal. Okay, that's what he held. Now, I told you before, I think there are some serious weaknesses in this opinion. Some problems in it. I'm going to tell you two of those problems. Okay, here's the first one. Judge Brier is saying that these conditions didn't exist. No rebellion, no danger of rebellion. But any lawyer will tell you that the first question you got to ask is, wait, who makes that call? Who decides whether rebellion or danger of rebellion exists? Does the President get to make that call? Or does the judiciary get to make that call? Judge Brier said, hey, it's up to me. So Judge Brier starts looking at dictionaries. He's got to define the word rebellion. Like I said, these statutes are getting interpreted for the first time here. I got to define the word rebellion, and I could tell you what definition of rebellion he chose, and we could talk about whether that made sense, but that's not what I'm talking about here. I'm talking about his initial decision that I get to decide, not the President, I do. Now, that's not crazy. Judges have to interpret the meaning of statutes all the time. Nothing crazy about that, but there's a long line of precedent that says when Congress has empowered the President to take action, emergency action, military action, when a certain emergency or emergency conditions or some exigent circumstances exist, then it's up to the President to decide whether that threat to national security, that emergency, that exigency exists. I'm thinking in particular of a case decided all the way back in 1827 by the Supreme Court itself. And it was a surprisingly similar case in some ways. It was about whether the President had authority to call up the militia, and we call the militia today the National Guard, had the authority to call up the militia under a statute that said, yes, you do have that authority, Mr. President, but you only have it where there's in cases of an invasion or the danger of an invasion. And somebody was saying, hey, there was no invasion, there was no danger of an invasion, so the President's call up of the militia was unlawful. The Supreme Court said, no. We are of the opinion, said Justice Story, a very famous justice, we are of the opinion unanimously that where Congress has said that in the event of an exigency, the President has the power to use the militia or military force, it is up to the President to decide whether that exigency exists, and his determination of whether that exigency exists, quote, is conclusive. That's what the Supreme Court said back in 1827. Now that Supreme Court case from 1827, it's got some differing facts. There's some ways that maybe it doesn't 100% exactly apply to today's case. So I'm not saying four square, on point, clearly makes Judge Brier's ruling wrong. But what I am saying is it is hard to square what the Supreme Court said in 1827 with giving no deference whatsoever to the President's decision, determination about whether a rebellion or danger of rebellion exists, which is essentially what Judge Brier did. Essentially what he did is, hey, President gets no deference on this, it's up to me. And I don't know if you can square that, no deference, with this long line of precedent, starting with this 1827 case. Okay, so that's the first problem, and it's a big one. It might be the grounds on which the appellate courts or the Supreme Court itself might eventually reverse him. But there's a second, equally important reason, maybe even more important. So far, President Trump's authorization, his orders to the National Guard and to the Marines, all he has ordered them to do, all he has authorized them to do, is to protect ICE agents and federal property. Now, this is very important. In other words, he hasn't said, I'm going to have them patrol the city streets of Los Angeles. I'm going to have them stop the looting. I'm going to have them round up aliens and arrest aliens and enforce the immigration laws. No. So far, all he has permitted and authorized and ordered them to do is to protect ICE agents and federal buildings from violent attacks. Why is that important? Well, legally speaking, could be very important. Lots of lawyers Many people believe that the president has an inherent constitutional power and authority to do just that. That is, to exercise what they call the protective power, to use military force to defend federal agents and agencies and functioning and properties from violent attack. The idea here is the president is not obliged to sit in his hands if folks are out there violently attacking federal employees or officers or federal buildings. No, he's got the power to do something about it, especially if local police aren't able to handle it. But regardless, he's got the power to protect federal employees, federal properties, federal functioning. That's called the protective power. Arguably, presidents have been exercising that power for hundreds of years. And for at least the last 50 years, it's been the formal position of the White House that the president does have that inherent constitutional power, regardless of what statutes might say. Now, Judge Brier, he conceded that so far, all the president has done is order the National Guard and the Marines to defend and protect federal agents and buildings from violent attack. He suggests that maybe the president might go further at some point, and maybe the president might, but he concedes that at present, that's all the president's done. But then Judge Brier doesn't confront or deal adequately with this argument that, well, that means that what he did is within the long tradition of presidents exercising what's called the protective power, the power, once again, to call up the military to defend federal agents, properties, and federal functioning from violent attack. Again, serious problem or weakness in Judge Brier's opinion that may be cause for grounds for reversal, either in the appellate court or in the Supreme Court. Now, let me tell you just a little bit about Judge Brier's best argument. His best argument, he points to the fact that this statute says that the National Guard can only be called up under certain conditions. He notes that in that statute it says the orders shall issue through the governor of the state in question. Well, that's a peculiar phrase, shall issue through the governor. What does that mean? Nobody knows what it means. We've got almost no interpretation, no judicial, no case law interpretation of this. Now, Governor Newsom's lawyers were taking that phrase and kind of arguing that that meant Governor Newsom had to consent to the president calling up the National Guard. Most lawyers don't believe that those few words in that statute have that meaning. They think, no, the president doesn't have to get the governor's consent. LBJ did not get Governor George Wallace's consent when he sent the National Guard to Alabama. The president doesn't have to get the governor's consent to call up the National Guard. That's not the way these things work, most lawyers say. On the other hand, that phrase is there, and at least it suggests there might be some procedural hurdles or procedural rules that the president's supposed to go through the governor when he issues these orders, and arguably, President Trump went through the wrong officer, didn't go through the office of the governor itself when he issued these orders. Now, that's a different argument. It's actually a little bit of a stronger argument, but as I see it, it's more procedural than substantive. Okay, let's talk about taking a big step back. How are we supposed to think about these issues? Bottom line, ultimately, how are we supposed to think about it? Well, let me tell you a little bit about how I think about it. I think we got to have a little more common sense here and a little less hysterics about what's going on. Yes, giving the president the power to call up military force into our streets, that's a dangerous power. You got to watch out for that in a free country. That can be abused. Most Americans, they don't want to see tanks rolling down their city streets. They don't want to see troops marching down with machine guns in their city streets. When the president has the power to call up the military or the National Guard into our streets, civil liberties can be trampled. If those troops take action, use force against peaceful protesters, against peaceful folks just assembling, that's a huge problem. That's a huge constitutional problem and a threat to civil liberty. If those troops are just so present and are making such an intimidating display of armed, massive force that citizens don't feel free to go out in the street and go about their business, that they don't feel free to say a dissident word. What if those military forces are starting to be used to attack or harass the president's political enemies? All of that can be a grave danger to a free country. But a limited use of the National Guard or the Marines to quell riots that are happening in the streets, is that a threat to a free country? Well, look, I guess in part it's going to depend on how bad you think the violence was. In fact, as you know, a lot of the president's critics are saying there wasn't much violence. There wasn't real violence until the president ordered the National Guard there. Judge Brier himself issued factual findings that tended to take that view, and that could be another problem with his opinion, by the way. It's not clear it was appropriate for him to issue those factual findings based on the evidence he had before him. But I guess it's going to depend in part on your view of how bad the violence was. The New York Times recently published a piece saying the violence in LA recently, that was just mere skirmishes compared to the Rodney King riots of the early 90s, when the president sent National Guard troops into LA to quell that violence. Mere skirmishes, said the New York Times. Well, you know, maybe it doesn't disturb the comfort of New York Times editors when cars are being torched in the streets and when there's a couple $1 million of looting damage in downtown Los Angeles. Maybe that doesn't disturb the comfort of New York Times editors, but maybe there were a lot of folks in Los Angeles who were happy to know that federal armed help was on its way and was present to stop that rioting and violence in the streets of Los Angeles, especially when their mayor herself declared that her local forces, her police forces, were overwhelmed. I'm guessing a lot of folks in Los Angeles were happy to have and happy to know that there was going to be some armed federal forces to help stop that violence and that rioting from being out of control. In my opinion, a limited, time-limited, space-limited, limited use of federal armed force, whether it's the Marines or the National Guard, to quell, to put down rioting, torching, looting in the streets of a city, that's not a threat to a free country. That's my opinion. We'll have to see what the appellate courts do with Judge Brier's ruling. Until then, I'm going to say goodbye for now. I'll see you next time.